Okay, let me welcome all of you and thank you for joining us. Before we get into some introductions, let me just let you know that we are recording this webinar. And we do plan to post it to our site for any of you who might want to go back and relook at some of the information that we're going to share with you or to share it with colleagues that you might have. And the account execs at First Point will also have the link that they'll be able to send out to you as well, or to any of the individuals that were not able to make the call today. So just so you all realize that. My name is Scott Hall. I'm Senior Vice President and responsible for the Information and the Background Screening Resources Division here at First Point. And we're very excited to have the opportunity to talk with you today about something that certainly is going to impact all of us as we go forward in the future. And we appreciate you joining us. We will be good stewards of your times. We have plans of making sure that we are all out of here by the 11:30 time frame. We do have you all on silent mode right now since there are so many, to make sure that there's not too much background information as you were listening. If you do have questions, what I would suggest is you should have a box where you can type a question in and submit it to us. And then when Beth finishes her part of the presentation, we'll check the questions and go through and answer those questions. And then when Jennifer finishes her part, we'll also look at any questions around the FCRA, so that way we can allow everyone to be able to hear clearly. So thank you again. First of all, I want to thank those of you for your relationship and for trusting us to work with you in handling your background screening needs. And we also want to welcome some of the clients that are with us from Beth Langley's firm as well to our group, and appreciate your attention. You all saw Beth Langley's bio in the email that was sent out. What I will say on a personal note is I've worked with Beth for in excess of 10 years as one of our primary corporate attorneys, and particularly as it relates to all the employment law issues, and she is one of the best of the best. So we're very excited to have her with us today to share from her perspective what the new EEOC guidance is going to mean to you. And then while we had you all together, we wanted to take the opportunity with Jennifer Smith, who is our Director of Compliance and also handles the training here at First Point, to talk to you just about a few things that we constantly hear from our clients around FCRA. Some possible misunderstandings, some confusion that there may be, and just kind of an opportunity to refresh you on a couple of things that might be important to you. So we'll kind of do this in two different segments as we get started. So with that, we're going to turn it over to Beth and let her jump right in.
Thank you. Thank you, Scott. Thank you all for being here. And I need to apologize. I've got an unfortunate and untimely cold, and so I'm going to talk as loudly as I can, and hopefully you won't have any issues hearing me. This is a very timely topic, and I want to really thank Scott and really kudos to Scott and First Point for putting on this presentation, because almost immediately after the EEOC issued its guidance, Scott reached out to me and said, Beth, would you help us put on a webinar for clients and employers so we can put some information out there on what this guidance means to employers, because it really is a paradigm shift. And so we put our heads together, we went through the materials and put this together just as fast as we could, because April 25, this was really news to all of us. The EEOC, I'm just going to give you a little bit of background before we get into the materials. The EEOC issued this guidance at the Commission's regular meeting on April 25, and it was really out of the ordinary in how the guidance came into place. Generally, when the EEOC issues a guidance, it goes through the established rulemaking procedure where the guidance is submitted for comment through the code of the CFR, through the Federal Register, and it's submitted for comment for a period of time whether it's 30 days, 60 days, sometimes even 180 days. And there is a comment period for all stakeholders. And stakeholders is, we're talking about citizens, everyone who is affected. And in this particular situation, there had been a request by the Senate Appropriations Committee that oversees the EEOC for a comment period, but I'm not in that loop, but for whatever reason, the commission at its meeting on April 25 just took this draft that had been prepared and immediately enacted the guidance effective immediately, which is rather extraordinary for not just rulemaking, but for a guidance. A guidance is not a regulation, but from the EEOC's perspective and how it runs the agency, it treats the guidance that it puts out there as if it is a regulation from the manner in which it interacts with employers. The EEOC says this is the standard. And so my point to you is that this was an aberration, and there wasn't a whole lot of time to get, there wasn't a whole lot of notice for us to say that we think this should be a different way. The employers didn't have a lot of input to say, the background screening, this whole standard really should be a different way, or the guidance should be drafted some other way. My other caveat is, I guess, hold on. Don't get too comfortable with this.
Has joined the conference.
Because this may not be the end of it. As of last Friday, the House of Representatives passed an appropriations bill for the EEOC, funding the EEOC, but with a carve-out that would not fund any activities that will enact or further the implementation of this guidance. Now, I don't have any information as to where that stands with the Senate, because in order for that to become law, the Senate would have to pass something similar. But there is a back and forth, and I think there is going to be a lot of activity both at the legislative level and probably in the courts with regard to this guidance. But for right now, this is the law. And if you have an EEOC charge, if you're conducting background screenings, we all need to realize that this is the guidance that the EEOC is working under. So in my presentation, what I'm trying to convey to you is not just some best practices, but I think from I hate to use the phrase common sense, but really kind of a common sense. How do you operate under this guidance, realizing that there's a lot of ambiguity and some murkiness out there? So with that said, here we go. The background, the laws that we're dealing with, there are two of them. There's Title VII of the Civil Rights Act of 1964, with which I'm sure you're all familiar because you're on this call, and the Fair Credit Reporting Act. Now, prior to the April 25 guidance, the EEOC had spoken on this issue, and the EEOC had a general enforcement guidance that did discourage employers from inquiring about arrests in employment decisions, because there was a concern that there was what's called disparate treatment, meaning that there was discriminatory treatment, adverse impact on certain minorities. And generally that concern, the minorities they're concerned about are African Americans and Hispanics. And the guidance that had been in place encouraged employers to look at those underlying circumstances of not look at the arrest, and to look at the underlying circumstances of any criminal conviction in relation to the particular job when making an adverse employment decision. And that was the law. And it was also consistent with the court decisions that were out there. And it made a lot of sense. When you couple that with what's in effect with the Fair Credit Reporting Act, which requires any employer who's going to do background screening in the employment context to obtain voluntary consent and also to provide some really detailed notices to applicants and employees who are going to be the subject of criminal background screenings when it's conducted by a third party like Insight. There are already safeguards in place. There are what we refer to as the CRA, the Consumer Reporting Agency like Insight. You can't report records of arrest for more than 7 years old. So again, that sort of had a parallel track with the EEOC's concerns. And although the FCRA did not limit reporting of convictions, the FCRA certainly has very extensive mechanism for disputing any inaccuracies in background screenings. So, and Jennifer is going to give you a lot more information about the FCRA when she talks. But from what you see in this current EEOC guidance about their concerns about inaccuracies in reports, those concerns are addressed in the FCRA in how inaccuracies are dealt with, handled. Disputes must be very timely addressed by a consumer reporting agency. The EEOC's concern with criminal background screening, as I said before, really has to do with their focus on statistically a disproportionately high incarceration rate and high arrest rate of African Americans and Hispanics, particularly men, compared with the general population. So what they're looking at is what's called disparate impact discrimination. Under Title VII, there are two types of discrimination under which an employee or an applicant can pursue. There's disparate treatment discrimination and there's disparate impact discrimination. And if you'll stay awake or take another sip of your coffee, I'm going to give you just a tiny primer on the distinction between the two, because it is important for this guidance. Now, we know what Title VII protects, race, color, sex, and religion, national origin. But let's start with disparate treatment, because that's the easy one. That's the one we all know about. Disparate treatment says you can't treat people differently on the basis of race, color, religion, sex, national origin. So let's put that in the context of background screening. Let's say your company has an African American candidate, and you do background screening, and you have a policy that says we don't hire anyone with any criminal convictions. And the African American candidate had a nonviolent misdemeanor offense that occurred 10 years ago. Now you have a white candidate who has a similar offense. Let's just say it's possession of marijuana, but this white candidate happens to be the son of the friend of the vice president. And I'm sorry, it happens. Well, that is an example of disparate treatment. If the white candidate is hired, the African American candidate is not, that would be what we call a prima facie case of race discrimination, because the two were treated differently. The policy says we don't hire anyone who has any convictions. An exception is then made for the white candidate because, oh, we know this person, he's okay.
Join the conference.
The argument would be, oh, well, there's a stereotype that we're not going to hire the African American candidate. That's the classic disparate treatment discrimination, and something of which you need to be aware and continue to be concerned. That if your organization is going to use any sort of background screening, that you must have, and we'll go through this, you must have consistent practices. And in this guidance, the Commission has said no longer may you utilize no conviction policies. I'll talk about that a little bit later in some best practices, but that blanket no conviction policy will no longer fly. And likewise, what has pretty much always been the rule, the no arrest policy is certainly not going to fly. You're really setting yourself up for problems with that. So let's go to what the Commission is really focusing on in this guidance, and that is the disparate impact discrimination. Disparate impact is often thought of as the facially neutral policy. It's the policy that applies to everybody. It's applied the same way to everybody, but unfortunately it has a negative impact on one particular protected category. I remember that the way I sort of understood this policy this doctrine when I was in law school was an example of prison guards. The prison had a policy that said, we'll hire anybody, but you must be 6 feet tall. Well, or maybe it was 6 feet 2 inches tall, but that facially neutral policy had an adverse impact on women because most women are not 6 feet tall. You can have that policy, that facially neutral policy, but the employer must show, and the burden is upon the employer to demonstrate that what's called the challenged practice is job-related and consistent with business necessity. Now you ask me what the heck that means. We'll talk about it. Because that's the kind of things redundant to me, job-related and consistent with business necessity. But in that case, and there actually was a prison guard case, the employer, that state, was able to show that it was job-related for the prison guards to need to be of a certain stature for security reasons. It was job-related and consistent with business necessity. So really tall women could get the job. But that is and that was in the male side of the prison. But that's an example, facially neutral policy. So in 1991, Congress codified various Supreme Court decisions and amended Title VII to actually recognize this disparate impact doctrine. And so this is how it works. You got this, if there's a disparate impact on the basis of race, color, religion, sex, or national origin, then the burden actually shifts to the employer to demonstrate that challenged practice is job-related for that particular job
Has joined the conference.
and consistent with business necessity.
Has joined the conference.
And the bulk of the EEOC guidance really addresses this disparate impact, and they just come right out and say that the whole reason we issued this guidance is because of the disparate impact on African Americans and Hispanics as a result of the criminal background screening. So again, what we're talking about is facially neutral policy, criminal background screening. Does it have a disproportionately negative impact on a protected class? And the EEOC says yes. And this is why. Now, what they're saying is well, before I get to that, the disparate impact, what the courts are saying, a disparate impact is established by various ways. A plaintiff can say disparate impact is established by employers' inconsistent hiring practices, comparison of similarly situated. You go look at your workforce and the non-protected category versus the Hispanics versus non-Hispanics, African Americans versus non-Hispanics, or statistical evidence. So what you really look at is it's results oriented. It's how you look at, say, with criminal background screening, you would go at the workforce theoretically and see how it shakes out. And so in order to avoid Title VII liability, if a facially neutral policy has a disproportionate effect of screening out a particular group, such as a particular race, then that employer has to establish, again, that the policy is job-related for the job in question and consistent with business necessity. Now, this is what the EEOC says, and this is where, again, I think we're going to see either some litigation or maybe additional comment. What the EEOC says is that from their perspective, it doesn't matter what the employer's workforce looks like. That the employer's workforce can be okay, or there may not be a disproportionate or an adverse impact in the employer's workplace as a result of the background screening, because nationally these statistics indicate that there is that African Americans and Hispanics have more contact with the criminal justice system. Therefore, there is a disparate impact by using criminal background checks. That's what they say. Per the EEOC guidance, in 2010, 28% of all arrests were of African Americans, even though African Americans comprised approximately 14% of the general population.
Has joined the conference.
And in 2008, Hispanics were arrested for federal drug charges at approximately 3 times the rate of the general population. African Americans and Hispanics are incarcerated at rates that are disproportionate to their numbers in the general population. And so based on the statistics that the EEOC has cited in its guidance, the EEOC concluded that criminal record exclusions, meaning excluding someone from an African American or a Hispanic from employment based on a criminal records background check, has a disparate impact based on race and national origin. That's their conclusion. Therefore, they are necessarily saying the burden every time is on the employer to show that it is job-related and consistent with business necessity, regardless of your other policy, regardless of what you're doing, regardless of whether or not you have a diverse workforce. That's the conclusion. So that means every single time you've got to be ready to show that your criminal background check was job-related, that that it's consistent with business necessity, that you've conducted the check, the background check with it, everything is in compliance with their guidance. Now, the problem, I guess I would say the challenge with that is that you're in what I'm calling the proverbial catch-22. because the recommendations that the commission has placed out there are doing things like making conclusions about how long ago a conviction is no longer relevant, which crimes are relevant to a particular position. And I'm giving you my thoughts are that we have criminologists who haven't figured that out. We have criminologists who haven't figured out the effects of recidivism and exactly how long, a particular, crime is no longer relevant. That's still a debate out there for folks who are experts in that, and I think that is a tremendous burden to place upon employers. Not even tremendous. I just don't see how you can do it. I'm just being frank with you. It also this guidance does not have any effect on other legal obligations you've got out there. You've still got negligent hiring and retention issues. There's still workplace violence issues. I took some time to look at the OSHA website. Homicide is the leading cause of death in the workplace. Not the leading, it's the fourth leading cause of death in the workplace. That's a typo. We'll have to change that when we post it. It's the fourth leading cause of death in the workplace. So please, we'll get that changed before we post it. I apologize. But it's the fourth leading cause of death in the workplace, and primarily women are the victims. You still have theft and fraud as huge concerns, not just of the employer's property, but of theft and fraud of your customers, your patrons, your vendors' materials. And then you've got licensure requirements. And what the EEOC is saying about the licensure requirements is that if it's a federal licensure requirement, then the EEOC guidance does not apply. Federal law preempts. If it is a state or municipal licensure requirement, then too bad. The EEOC guidance trumps it. And you've still got to go through all of the job-related and business necessity. So, you think about practically just in the state of North Carolina, every job, every employer that has to do by state mandate background screening, and it's long. I mean, down to morticians, but it's really long. The licensure requirements that the state requires, and there are really legitimate business reasons for that. These guidance don't take that into consideration. They just kind of lump them into the pool of everything else. So, I guess we could all kind of complain and say, throw our hands at what we're going to do. But knowing this is where we are for now, at least, how do we work our way through it in a logical, orderly manner and protect your organization? And frankly, protect your employees and do the right thing by your applicants. Because I think that I've never worked with a company who wanted to do the wrong thing. So how do we do the right thing in light of the guidance, which frankly I think the commission, I think the EEOC was trying to do the right thing, but in light of where we are, what do we do? Well, first off, easy answer is let's start with arrest. We know that arrests cannot be grounds for an adverse action. But let's put a nuance on that. The guidance was clear, and rightly so, that the facts underlying arrest can be the basis for an adverse action. And let me give you an example of that. Let's say you do a background screening, and it shows, and this is actually an example from the guidance. It shows that there was an arrest for a sexual assault of a school employee, but it was only an arrest. You're the employer, and you're interviewing this individual, and you ask him, that was the example, it was a male, what were the background facts? What were the facts underlying it? Because that's now the new duty, is to get additional information. And this individual tells you, I was an assistant principal at a school to middle school children, accused me of inappropriate touching, and I was fired. So you pick up the phone. Because it's a school, we now can have additional public information. You get additional information, and that appears credible. And based upon the facts underlying that arrest, you make a decision not to hire that individual. You do not base it on the arrest on the background screening. You based it on the facts, the facts that you did, your own investigation, underlying that there was an arrest on there. The EEOC says that's okay. That is job related, and that is consistent with business necessity. It is a position, you're a school employer. It's a position that will be around children frequently, and therefore there is neither a disparate treatment nor a disparate impact from even the fact that you had a background screening, or that you got the initial information that you started that investigation from the fact that there was an arrest on the background screening. So, hope that's clear. Convictions. We now know that you can no longer have blanket policies where no conviction, no job. That has long been a policy with many, many employers. That's no longer acceptable. Now, in this guidance, the Commission, this was kind of interesting, they are recommending but not requiring that job applications no longer have the question, have you been convicted of any crime other than a minor traffic violation? What they are recommending now is that you only inquire about the criminal history when a conditional offer is made. Something similar to the ADA issue. Like in the ADA world, you can only make medical inquiries when that conditional offer is made. You can only require someone to have a job-related physical when the conditional offer is made. So this would, in this situation, my recommendation would be go ahead and take it off your application. And then at the time you are ready to extend an offer, ask the question. You can let folks know ahead of time that their employment is going to be conditioned upon a background screening. But I wouldn't ask the question until, or maybe not ask the question at all, but just tell them that employment will be based upon a background screening if it is. And if you're going to ask the question, then have it at the same time when you're going to do a drug screening and actually conduct the background screening. What the guidance also says is that you must now engage in a case-by-case analysis for each applicant, and I put employee because if you're going to do background screening for promotions or some other job transfer or whatever, and this is what we're calling the green factor. There was a 8th Circuit case, and the name of the case is Green. And these are the factors that the court set out that the EEOC has adopted. And it's actually a 40-year-old case. And what they say you have to look at is the nature and gravity of the offense or conduct, time that has passed since the offense or conduct occurred, sentence was completed, and the nature of the job held or sought. Now, they gave an example of one case that they relied on pretty heavily. It was a transit authority case from up in Pennsylvania. A gentleman had been convicted of second-degree murder some 20 years earlier, and he applied for a job, applied for a transfer, and they did a background screening. He didn't get the job. They found out he had been convicted of second-degree murder, and he sued because he then lost a job because he had not disclosed this earlier. And on appeal, he ended up losing the case. And there was some, what we call dicta in the case, where a judge kind of says something offhand that says, well, if he had had an expert that said the recidivism rate for second-degree murder is a short window of time, then maybe we would have considered this, but he didn't have it. So the EEOC says, well, now the employer must have some expert information on recidivism rate. I don't see how you get that. But the thing was, the guy had, if you really want to look at the facts, he had been in prison. He hadn't been outlawed. So when you start looking at the time that has passed since the offense or conduct occurred, sentence completed, you've been in jail forever how long, and you get out. I mean, it's relevant, so look at it. But you really do have to look at nature and gravity of the offense, time that has passed, and nature of the job held or sought. And you've got to make sure when I say you, I mean your organization, is applying that consistently with among each job and within the organization. And you'll see when I talk about some best practices that I do recommend centralized hiring and employment decision making, because if you've got, the more decentralized you are, I think the greater risk you are of having inconsistent application of these different policies. Somebody else may say, well, I don't really care about whether someone has a drug offense, and someone else will say that really doesn't matter to me, that sort of thing. And then you've got to provide the applicant or employee an opportunity to explain the circumstances if you're going to exclude them based on the criminal background check. Now, let's be clear about that. You may be excluding them for some other reason. They may just not be qualified for the job. Now, this is one reason that for hiring purposes, firing, demotion, layoffs, whatever, I am a big fan of a spreadsheet. And everybody every applicant, not if you just got tons of them, but when you're down to the finalists, I'm a big fan of a spreadsheet and objectively what the factors were and why you made your decision, so that you can objectively defend yourself later. And it may very well be that someone had a conviction or arrest or whatever on their criminal background report, but that had nothing to do with why you didn't hire them. Perhaps they didn't have the requisite certification. But there could have been a whole lot of reasons. But make sure that you are very clear on the reason for your decision. I think it's even more important now that employers, again, update those job descriptions and update them in a different way. I spent some time looking at the NIOSH website, National Institute of Safety and Health, and kind of looking at why, the types of jobs where employees get injured on the job, hurt on the job, killed on the job. That's when you start looking at job-related reasons consistent with business necessity. Why are we doing these background screens? That's the question. Why are we doing it? Are you doing it for certification? If that's the reason, that should be on your job description. Now, if you're doing it because someone has to drive and they can't have, they've got to have a clean driving record, then that should be on your job description. If you don't want someone to have any sort of drug or alcohol charge if they're going to be driving for your business or operating machinery, those should be, it should state that on your job description. Other examples, if you're doing job description, background screening because you want someone who is trustworthy, you don't want any fraud or financial crimes out there. You got people. Is it a job that handles money? There is a correlation between jobs that serve alcoholic beverages and certain crimes. Jobs that have access to sensitive financial information. Again, jobs that have access to patrons' valuables. Be that specific in your job descriptions. Work in close proximity to children or to the elderly or patients. If you're in a healthcare facility or assisted living facility. Is it a security position? If so, just be very specific about those. Inventory control. Is it a mobile workplace? That was really interesting to me when I looked at the NIOSH website, that is one of the highest crime-related jobs, but it's also one of those jobs where someone has so much autonomy that you really want to make sure, they're driving a vehicle, they've got a lot of autonomy. You want to make sure that you've got someone who is not, doesn't have any sort of criminal record, because they're taking patrons in, say a taxi driver, they're taking patrons into that vehicle and have a lot of discretion. Someone who works in a stressful environment, that just takes us straight back to workplace violence and these horrible cases that we hear about every day. And that is a straight, just a straight shot to the negligent retention, negligent hiring cases now. And unfortunately, that's just the world we live in. Delivers passengers, goods, or services. These are just sort of examples of things that you think about when you're writing those job descriptions, so that your job description states why it's job related to conduct the background screening. What's the business necessity? Again, works at night, works alone. So talking about best practices, I touched on this before. Document those objective factors for your employment decision. If the background screening results are a factor in the adverse decision, document why. Why was it specifically? Because as an employer, you by statute have the burden of proof to show job-related and business necessity. So make sure you can back it up in court. Review prior employment decisions for consistency. Before you make a final decision on this, if you're basing it on a background screening, make sure that you are looking at what has your organization done in the past, and you're not inconsistent with what your decisions have been. And again, I can't emphasize enough about centralizing those employment decisions as much as possible. It doesn't mean that your frontline supervisors and managers can't have input, but there really does need to be oversight from a central place. And at this point, before we move on to Jennifer, if you all have questions.
Yeah, let's look here and see if we've had some submitted. I can't tell. What we're going to do is we're going to take you off of mute, and if you've got a question for Beth or anything specific about, or anything that she didn't mention today that you were wondering about the EEOC guidance, this is a good time to ask it, and then we'll take a few minutes after that and let Jennifer talk about the FCRA thing. So I'm going to take us off of mute, and that's what I thought.
The conference is now in talk mode.
Okay, so we are off mute and we can all hear each other now. So if any of you have any questions specific for Beth that you'd like to ask, now would be a great time to do that.
Will this PowerPoint be available to us to distribute to our other offices?
Yes, we're going to make it available on our site, and you'll be able to go to firstpointresources.com and get access to the site. It'll probably take us a day or two to get it out there, but yeah, you'll have access to it.
Hello? Hello?
Yes. Did you hear my response?
Yes.
Okay, great.
Hello? I don't think they can hear me.
Yeah, we can hear you.
We can hear you.
Oh, you can? Okay. I wanted to add a question. I have the background check that you guys do at First Point, but our employees also have to go through a second background check that allows them to get a airport badge. Does that impact how we should word the criminal background wording on our application, or you still suggest that that should be removed until we actually extend an offer?
Is the airport badge, is this a federal requirement or a private requirement?
I believe it's a federal requirement because it has to do with the airport.
Okay. Are you a private employer?
Yeah.
Okay.
We are.
Okay.
We still, yeah.
If you're a private,
airport.
okay, if you're a private employer, even though it's a TSA requirement, I'd still remove it from the application and do the condition, make the conditional offer and just make it clear to them when they apply that they'll have to pass the background screening and the additional airport TSA screening.
Okay.
Hello?
Yes.
I have a question. On our application, one of the questions is, have you ever been convicted of any unlawful offenses other than a minor traffic violation? Should that be removed?
Yes, that's what the EEOC is now saying. You should remove from the application, and you can tell applicants that if they're offered the position that they will have to undergo a background screening. But what they're saying now is just that take that question off, and when you make an offer, make it conditional upon the background screening.
Yeah, the thing.
I have a question. So you can't place that exact information on your application?
That's what they're saying. Well, the way they worded it is they recommend it. So I'll tell you, when the federal government tells me they recommend something, I take the recommendation.
And you mentioned that you can't go back any further than 7 years. Is that correct?
That's an FCRA issue, and that's on arrests. The FCRA does not allow criminal background reports to contain arrest more than 7 years. Now, what the EEOC is saying is they do not want you to consider to base an employment decision solely on a fact that there is an arrest. You can look behind the facts of the arrest, but you can't just not hire somebody because they've been arrested.
Yeah, I want to just add to what Beth said and some of the research. This is Scott. Some of the research we've done about, you may have heard the phrase "ban the box," and that's in reference to asking the question, have you ever been convicted? Where the EEOC is coming from what we understand, and to kind of reiterate what Beth says, it's not that you can't ask the question, it's where you do it.
Yeah.
And they suggest that it no longer should be done on the front end at the application process, because what's the point at that particular time of knowing the information if you don't even know yet if you're going to be interested in hiring the person? So ask it at the point in time that it's relevant, which is when now you're going to make a conditional offer, and now it matters or not what the background screen information may be. So it just helps you look as though you're not doing any disparate treatment based on how that question's answered, by not asking it at the beginning of the process, but at asking it more towards the end of the process.
I see.
Yeah, that's very well phrased. Scott phrased it very well.
I have a question regarding that thing. So when you're in the interview process, can you ask them, because I can't consider somebody if they have any theft issues, can I ask them in the initial interview?
Asking them is the same, really is the same as putting it on the application.
Okay. So when so it's not until, they can meet all the essential functions of the job, but they may have a background issue. So I would just say, I'd like to offer you this job if you can pass this background check and drug test.
That's right. And you can put out there what the essential requirements are going to be, which is going to be successfully passing the background screening, and that, say that say your organization is a child care facility or something like that, and so they can't have any incidents that show up. You've got to have a clear background screening, or whatever. You can put that in there as an essential function.
Yeah, one thing we have suggested to folks about the quote ban the box question on the employment application is to remove the direct question. But there's the area on most applications where the employee signs, testifying, certifying that everything's accurate and correct, is that you can add language that says that you will need to successfully complete a background check and or drug testing, whatever your policy is. So you're telling them up front. So hopefully they're gonna weed themselves out by going, well, oh gosh, if they're going to do a background screen, I'll never pass it, and they won't pursue it anymore. So you can certainly, on the application, I would change the question, instead of asking, have you ever been convicted, and put the statement that part of our hiring process will be you will have to successfully complete a background screening and drug testing. So you are letting them know up front, and hopefully that'll help you weed some of them out.
Okay, because we see that on an application saying, you're subject to substance abuse and background check.
Right, and that's the thing is, but just removing the question, certainly let them know it, but don't ask the specific question right then.
Okay.
Can you take the example of a child care facility a little deeper into our state regulators, which some of us are required to have employees who pass fingerprint background checks? Can you think through whether that becomes a business necessity, or whether our federal regulators are going to require us to expand our factual inquiry beyond the ability to provide us with a fingerprint clearance card?
I think right now, continue to do your business as usual, because for child care facilities, that is job-related and consistent with business necessity, and the state will take this on if they want to challenge it.
Thank you.
But if you go through good question. If they go through the mentality, we're talking about airport employees that are required to have an airport ID cleared by TSA or authority in customs. It's a job requirement for them not to have any convictions or arrest with drugs or theft. So in that mentality, we're still able to ask that question.
Are you in a...
Is it a necessity of the job for them not to have convictions or drug-related charges or weapon-related charges?
Is that from a federal contractor requirement?
Yes.
Okay, then that's a federal requirement which is preempted by these guidelines.
Yeah, as usual when the EEOC comes out with their guidance, the government always gets to exclude itself from any of the laws that it holds us to. So yeah, anything that's federal mandated basically is not really a part of the EEOC guidance. Any other questions at this point in time?
Yes. What about the difference between applicants and folks up for promotion? Would you say have uniform standards?
Yes, you really need to have uniform standards and treat the applicants and employees the same. I mean, you're not going to have an application for a new employee, but you would still tell for an employee up for promotion, but you would still let them know that a condition for the promotion will be successful completion of a background screen, or and still have the make sure that you've got that job-related business necessity covered on the job description and that sort of thing.
And Jennifer's actually going to touch on that in just a moment, because there's some things about FCRA as it relates to whether you're doing pre-employment hiring or whether you're doing promotion transfer type stuff that Jennifer will touch on in just a moment. So give you some further clarification. Okay, well, for the sake of time, what we're going to do is I'm going to put you back on mute so that we can allow you to be able to hear Jennifer without any issue.
The conference is now in silent mode.
And I'm excited to introduce Jennifer Smith to you. Jennifer is our compliance officer here at First Point, and also, like I said, handles our training. And the FCRA is very much tied into the EEOC. They kind of go hand in hand, and we know that over time we hear a lot of things from our clients around FCRA type related items. So Jennifer wanted to take just a little bit of time and share some things and clarify some things, but also make some connections between what the FCRA is and the EEOC is with the guidance that's come out. So at this time, Jennifer, we'll turn it over to you.
All right. Good morning, everybody. So we'll go to our first slide here and talk a little bit about
Has joined the conference.
talk a little bit about some myths around the FCRA and just background screening in general. One of the ones we hear a lot is people think that there
Has
is
joined the
a
conference.
national database of criminal records and we should just be able to search one place and find out everything about everybody. That's not true. While the FBI does have a database, it's not available to most employers. In fact, it's a very limited pool of people who have access to that information. Although we do sell something that is a more comprehensive search than just by looking in one county or one state.
Has joined the conference.
That is not all inclusive, and there's no one place to go. Another thing that we touched on earlier is how far back records can be used. What kind of information can be in a report and what cannot be in a report. As Beth stated earlier, you can only show arrests that go back 7 years. So if somebody was arrested 12 years ago, that information would not be included in your report. You can, however, use convictions for an unlimited period of time, depending on the state. There are probably a dozen or more states that have their own versions of the FCRA, some of which are more restrictive than the federal law. Some of those states have these rules in place, but they are preempted by the FCRA. Others came before the FCRA and are in effect. For instance, in California, you cannot use any record of arrest or conviction beyond 7 years. So in California, if somebody was convicted of a crime 12 years ago, again, we would not be able to show that in our report. Nevada, Mexico, and Hawaii are all similar in that they have restricted amounts of time that information can be reported. Hawaii actually goes back 10 years. So you get a little bit more information from them than you would in California. Other things that would be not included in the report would be records that have been expunged, or a record that's been sealed, or if an applicant was in some sort of diversion program, which would basically be you've committed a crime, but if you stay clean for the next 5 or 10 years and nothing else happens, that will go away, and that will not be something that could be reported. Another example of a state that has its own more restrictive version is Kentucky. They will only let you report convictions, period. There's actually no time limit. So if you were arrested 3 years ago, that information would not be included in the report. In Hawaii, something we were kind of touches back to what Beth was talking on using criminal information in general, you cannot even ask or know about information until a conditional offer has been made. In Massachusetts, they have their version where employers may not, under any circumstances, inquire or maintain records related to first convictions for any of the following misdemeanors: drunkenness, simple assault, speeding, minor traffic violations, an affray, or a disturbance of the peace. So you get a free pass for the first time you do any of those things in Massachusetts. After that, they will show up on a background screening report. Another question we get a lot is about adverse action notices. This is when you may not hire somebody or retain them, or you might deny them a promotion based upon something that comes back in their background screening report. And that's the important part. If you decide not to promote somebody just because they're not qualified for the job and you're going to promote somebody else, and it has nothing to do with the background screening report, they come back and they both have the same kind of history, that does not require an adverse action notice. However, if anything in that report influences your decision, then you are required to send out the notices. And I say notices, and that's another point of confusion sometimes. When people question whether is it really necessary to send out 2 notices, even though a lot of the information seems somewhat redundant. In fact, you do have to send out both notices. The reason being is the first notice needs to be delivered to the employee or the applicant before any kind of adverse action is taken. Meaning you're thinking you might not hire them because of something in that report, but you haven't fully made a decision yet. The second notice has to go out once you've made that decision not to hire, promote, or to terminate somebody. So on that note, you also can't send them out in the same envelope. Well, we've had some people ask, can I just put them both in the same envelope and send it off to them, and it's 2 separate notices. The reason you can't do that is the intent of the first notice is to give that applicant or employee a chance to dispute any information in that report saying, you know, that's not really right, that wasn't me. So before you make a decision not to promote me, let me explain that, you know, that was my cousin who has the same name, that's not me. And that gives that person a chance to explain or say that the information in the report was inaccurate.
Jennifer, if I, or Beth, and I don't mean to put either one of you on the spot, but just for the folks that are on the phone, is there any rule of thumb around what's considered to be reasonable period of time? I mean, is it 5 days, 10 days, 30 days? Because I'm sure that's one of those areas of what one person may consider to be reasonable. Somebody else may say, well, you didn't give them enough time. Is there any thought process around that?
The FTC has opined that 5 days is reasonable, but there really isn't a set, you know, you have to wait a certain number of days. Again, the idea behind it is to give the person enough chance to actually have time to read and consider the information in the report and decide, is there something in there that I need to dispute?
And in practice, what I have found employers often do when the background screening does play a role is they'll often ask. They will often just ask the applicant or the employee what, you know, tell me the circumstances, because they many times don't want to exclude the individual from employment based on the results. You know, they like the person, they were going to make an offer, they want to get the information. So, you know, a lot of them are already doing what the EEOC is encouraging.
Right, and and that's a great point. So let me ask this again. Under the thoughts of best practices, if you have that conversation with someone and they say, yeah, that was me, yes, I did do that, that still doesn't prohibit you from having to send out a pre-adverse action and adverse action, or does it prohibit you?
You still must send it out if you're going to take the adverse action.
Right, exactly. So even with the conversation, you still have to send out a pre-adverse, then allow for the time, and then send out the adverse.
Right.
So you can't say, well, I talked to them and we know it's them and they admit it's them, so I'm just going to go ahead and adverse action on them. You still could get in trouble.
That's correct.
Okay.
Yeah, you still have to follow the FCRA.
Correct.
And another part for that, having to send out that first notice, is that you also have to send them a copy of the report so that they can actually look at it and have time to review it. And the FTC's summary of their rights. So just by talking to them, you wouldn't fulfill the whole obligation because you need to include those two things with that notice as well. Another common misperception we get deals with getting an applicant's consent and disclosure about a background screening report being run in the first place. So if you're going to run a background screening report for pre-employment purposes, you must get their written consent before the report is run. So you can't run it and then 2 weeks later go, oh yeah, we wanted to run this on you, so here, will you sign this? You have to let them know it's going to be done. That's the disclosure part. And the consent part is getting them to say, yes, it's okay for you to run this report on me. Some other confusion comes in that the way the law really reads is that this consent and disclosure needs to be solely a disclosure document, and that's it. But what the FTC has also said is that it's actually okay if you include a brief description of the consumer report saying, you know, we're going to check your employment history, we're going to check your driving records. That's okay to include that in your consent and disclosure form. It's also to include the part where they say it's okay for you to procure a report on me in that disclosure form. So those three things can all be in there without you having to worry about not fulfilling your FCRA applications. What they don't want is a lot of extraneous information so that the person has no idea what they're signing and they're not sure what's really going on when they sign. So you can't include your consent and disclosure as part of your application because that is distracting from the point of you saying we're going to or we want to run a background screening report on you. And a lot of times people will have just a little paragraph at the end of their application that says, oh yeah, and we're going to run a background screening report on you if it's okay, sign here. That you don't want to do. In fact, it's gotten a couple fairly high-profile companies in trouble lately that are in the middle of some lawsuits that you may have heard of. One is Domino's Pizza. They were recently sued for having issues with their disclosure as well as their adverse action process. They included, or they allegedly included, their consent and disclosure as part of their application. So if that is true, they have violated that piece of the FCRA. It's also alleged that they did not take proper adverse action when they did not hire people. They did not give them a copy of the report, nor did they explain that the other information included with your adverse notice. The Consumer Reporting Agency did not make the decision. They have a right to dispute any information in the report. Allegedly, none of that was done. And this is a class action suit. So for all those folks who have applied with with Domino's, this could potentially affect them. As I almost misspoke there, they're not the only ones who are undergoing the same kind of litigation. Capital One as well is accused of the same thing of including the consent as part of their application and not following adverse action procedures. But to get back a little bit to, as I skipped over here, the consent disclosure, another question we get is employers want to continually check the background of their employees. So they want to know, what do we have to do if we want to, make sure that they were fine when we hired them, but that was 10 years ago. We want to make sure everything's still fine and that they should be working here. You can do that. The key in that is how your disclosure is written. The employee needs to understand, and it must be clearly and conspicuously noted, that the employer intends for the disclosure and authorization to cover both the application process and the duration of their employment. Often you'll hear these referred to as like a one-time evergreen disclosure, where it's somewhere in there it says, while you're employed with us, we may at any time conduct a background screening report. So you can do it, it's just how you go about it that makes a difference.
Yeah, I want to add one thing here to what Beth had touched on earlier, and I knew Jennifer was going to get to this point, is a lot of times with companies, they won't have that evergreen language in their consent form, but it may be 2 or 3 years from now and they're looking at hiring, at promoting someone to a different position within the company or transferring them or maybe moving them into some type of a senior management situation, and then they want to go pull a background report on them. Well, technically and by FCRA, you can't do that unless you get that current employee to sign a consent form. And obviously, you probably don't want to get them to sign a consent form because now you're telling them that, hey, by the way, you might be up for a promotion or something like that within the company. But if you don't have the evergreen language in your consent form at the time that's signed by the employee. If later on you want to pull a screening report on them due to some other internal reason, you don't have the legal right to do it under FCRA. So we suggest that you put the evergreen language in your consent form, even if you don't periodically check background screening from a monitoring standpoint, because you never know when you may want to pull a report on someone, whether it's for cause or promotion or whatever the reason, and you wouldn't be allowed to do it because you didn't have their consent to do it at the time. So that's an important thing, is if you are doing that as a matter of promotion or any other type of internal thing, once somebody is already hired and you don't have the evergreen language, you are violating FCRA. If that employee were to find out that you did it, and then let's say you didn't offer them the job, the promotion, because of something that came back on the report, you're in hot water. And you're in a difficult situation. So evergreen language means more than just necessarily monitoring. It means any other opportunity where you might have a need to pull a report on someone for any other reason while they're employed with you. So we ask everybody to consider putting that type of language in their consent form to protect you down the road.
And you may run into situations where your insurance company requires it, and you don't want to have to go back and get consent forms from everybody.
Well, Jennifer, was there anything else you wanted to add?
No, I was going to say, if anyone has any questions.
Yeah, what we'll do is we're going to take you off of mute again and allow you an opportunity. Now you've got the wisdom of Jennifer and Beth.
The conference is now in talk mode.
Both here together. So any questions that you might have thought of relating to the EEOC guidance or anything that may have come up relating to practices around FCRA, we've got a few minutes here left. We'd love the chance to address those with you.
Okay. Well, the first is I have a question.
Okay, what's your question?
Regarding the evergreen language that you're speaking of, and I don't understand at what point how that is, I guess, given to the new employees so it creates a duration.
It can actually be part of the consent you use when you're initially interviewing and preparing yourself to perhaps you're interested in hiring them and considering them for employment, and you want to get that consent and authorization to run a report pre-employment. So you can actually include it in that initial release.
We have some examples of that type of information. So if you want to reach out to your account executive, we can get that information to you, or maybe at the very end we can give out some contact information if you've got any additional questions about that, and we can provide you some sample language that you could put in your consent form.
Thank you.
All right. I have a question regarding the application when you mentioned earlier taking anything regarding the question in reference to conviction. What if the application has conviction of a criminal offense will not necessarily preclude your offense? You still recommend taking everything off?
Yeah, could you restate it one more time? There was a little background noise and we had a hard time hearing your question.
I'm sorry. Okay, let's see if I can turn on my phone. The question earlier about taking the information regarding conviction off the application, what if you also have under that question, conviction of a criminal offense will not necessarily preclude your employment? You still recommend taking it completely off?
Yes, based on this guidance, I would take it off.
Okay.
Yeah, no, we would agree with that. Again, it's back to something that I said earlier about it's not that you can't ask the question, it's where in the process you ask it. And basically what the EEOC is saying in the guidance is it should be one of the last things you do before you officially hire them, instead of it being the first thing that you do as a part of the application process. Remember, I'm famous around here for, perception is reality. You want to make sure that you're putting a process in place that even by perception doesn't give any indication that you may or may not be discriminating. So by removing the question completely from your application, you're also helping to the perception that you're doing things correctly and that it's only when you're ready to make an offer that you even entertain about background screening, as opposed to giving the perception that at the front end, well, you say you don't pay any attention to it, so why did you even ask the question at this point in time?
Okay. Just so I understand, when we earlier mentioned the 7-year arrest, is that arrest and conviction or only arrest?
The FCRA says that you can only use arrest information for 7 years. So if it's beyond 7 years, you cannot use arrest information. Convictions, on the other hand, are indefinite, except for the certain states who have their own rules which are more restrictive than the FCRA and came before the FCRA.
Okay.
Yeah, there's no federal restriction on convictions. There are some state restrictions, but there are no federal restrictions on when you can report convictions.
And this is a distinction on what information you get on the background screening report. Versus from the EEOC standpoint, what you can do with the information once you get it.
Right.
Mm-hmm. So another question in reference to the adverse notice. So we're sending this out is it only for those that we're looking to potentially extend an offer, or to everyone that might not pass the background check based on what's on it?
You would send that out to someone who you intend either not to hire, not promote, or that perhaps is going to be terminated because of something that was in that report. So if there's somebody you want to hire and you like them, you do not need to send them that kind of notice now. Does that answer your question?
If you had an applicant and you really liked them, you were going to hire them, but the background screening came back that they had been convicted for murder, and you're like, oop, not going to hire them, they would get an adverse action report.
Okay, because our process is after it's post for running the background check.
You mean after you've made them the offer or after you have hired them?
After we've extended the offer.
Okay, so you're saying you've extended the offer, then you run a background screening report, and something in the report prohibits you from going ahead and hiring the person. You're asking, do you need to do adverse action?
Yeah.
Yes, the answer would be you would, because you're still using the background screening report to take adverse action on the applicant by not formalizing that offer after the report is done. So yes, you still need to do the pre-adverse and the adverse action.
An alternative you could do is prior to extending the offer, what you could do is run the background screening before, they could just be a finalist and you could do the background screening.
Correct.
Okay.
Okay. We hire contingent on the background, and sometimes people may have been working for a week or so, and then something comes back on their background, and we're not able to continue their employment because they can't pass for the airport badge. So are they supposed to be sent a letter as well? Is that something we can contact First Point to do for us?
Yes, you would still need to send a letter. And yes, we can talk with you about providing that service for you. We have other clients we work with and sending out letters on their behalf. So yeah, we can talk with you about that.
And we do provide a sample letter at the end of each report for most of our clients that has all the relevant language that needs to be in there. Is a guide for you, those letters.
This question is a little off. Would First Point have the capability of adding the E-Verify system with your system, or no?
Yes, we do that as a part of our I-9 process. We have an I-9 system that automatically connects up to the government's E-Verify system, and is something that we can talk with you about, whether it's a standalone, just E-Verify, or whether it's a combination of I-9 and E-Verify. It's an electronic system that allows you to move to a paperless environment from the way your paper I-9s may be today. So, yeah, I would suggest that you reach out to your account exec, or if you're not sure who your account exec is, I'll give you a generic email in just a moment that you can send us something, and we'll have somebody contact you.
Wonderful. And I used to use a system with a previous employer employer and E-Verify system. However, I know it's going to be mandatory to start using E-Verify soon.
And that's true. Depending on the state or the size you are of an employer, yeah, there's mandates about E-Verify, and we can certainly help you with that. We have several clients today we're working with on E-Verify.
Thank you.
Sure.
I have a question.
Okay.
We have an employee, we have an applicant that we're not going to hire because of something that was on her background check. So I heard something about sending one letter out and then waiting and sending another letter out.
Correct. It's called the pre-adverse action. You have to notify them that you're not going to hire them due to this particular reason and give them an opportunity to resolve it if there is something to be resolved. And then after that, you can formally then give them the adverse action letter. So correct. It's a two-step process to allow the applicant the opportunity to respond to the reason that you're not going to hire them due to the background check. If for some reason there's inaccurate data or it's incorrect or whatever the reason may be, you've got to give them an opportunity to say, hey, wait a minute, you're making a decision about something that's not correct.
Okay, so what's the time frame between sending the two out?
The first one needs to go out before you make your final decision, and then you're supposed to wait a reasonable amount of time between that first notice and the second one. Generally, the FTC had said 5 business days, but literally it reads a reasonable period of time.
Okay.
I have a question about the application part.
Sure.
We have a whole list of pre-employment certification where they initial off about the drug test and the background check and the at-will law for our state. Should I just pull that whole section and they'll only sign that when after the interview state and the supervisor is wanting to hire this person that they initial off on these?
Yeah, I think based on this guidance, I think the only modification you need to make is if you have on your application the inquiry, the question of have you ever been convicted of a crime or something like that. Otherwise, you're okay with those others. This is the at will and this this is not a contract and that sort of thing.
But it also, on that same page, has giving us authorization to do the background and the drug test.
I do recommend making the modifications to the consent to the background screening that Jennifer and Scott were talking about, because you do need to have a separate standalone consent. You can have that on your application, but you must have a standalone consent.
Okay, so can I combine the background and the drugs, since those are both conditions for our employment, and put them on a standalone and just leave this other stuff?
You must have a standalone background screening consent. It can't be combined with anything else.
Well, but it can include the drug test.
It can include.
Right,
the
yeah.
consent form
Yeah.
can describe the nature of the background screening.
it can.
What we don't, like you said, such as drug testing or a criminal background.
Correct.
That's okay to include that.
But don't include that with acknowledgement of your handbook and everything else. Yeah.
Right. Yeah, exactly.
Okay, because there were a lot of people talking. I wasn't really sure what the end result was. I can or cannot include with the okay to do the background check the drug portion as a standalone.
In the piece where they are consenting for a background check to be done, you can include that part of that background check will include a drug test.
Okay. Alrighty.
Okay.
Thank you.
Well, I would like to thank all of you for your time. We're coming to the end. I'm going to provide you a couple of pieces of information. One is, as we said, this will be posted on our website. So probably after Memorial Day weekend, we'll get a chance to get that out there. And you can go back and check it or send it on to colleagues. You can also contact your account executive if you have any additional questions that you want to follow up on or any additional services that we might could do for you as a result of some of the things that you have heard us talk about today. A generic, there's two ways you can reach out to us if you have any additional questions. One would be that there is an email address, info, I-N-F-O, info at firstpointresources.com. And you could just send it to that email. We'll get it in and send it to the appropriate person who can respond to what your inquiry is. Or you can go to our website, which is firstpointresources.com, and there's a contact us where you could write out your question or what your inquiry is, and that will also get directed to the appropriate person. So there's your individual account executive, there's info at firstpointresources.com, or you can go to the firstpointresources.com website. So I want to thank all of you for joining us. I want to thank Beth Langley as well as thank Jennifer. If you want to get in touch with either one of them, you can also use that method. Or you can, if you want to contact Beth about possibly some future questions you might have, or any other ways that she could help you, Beth.
Be glad to. My email is blangley, BLANGLEY, at hagendavis.com, HAGANDAVIS.com.
So great. So thank all of you. Have a great Memorial Day weekend, and we look forward to continue to serving you in the future.
Thank you.